environmental assessment, it's really a public information process, and we'll get into what that entails. And then with environmental protection, it would be, of course, fines and criminal offenses for committing to the pollution or things like that. So I want to start by explaining very briefly, very basically, what an environmental assessment is. What is an environmental assessment? So Canada has what they call their Canadian Environmental Assessment Agency, CEAA. There's a provincial equivalent. It's called the British Columbia Environmental Assessment Office. They usually refer to it as the EAO. An environmental assessment is triggered any time that the government is making a decision that might affect the environment. If they're funding it, if it's going to be involved, if it's going to be on government land, if it's going to be something that is approved by one of their departments. I can say this much about environmental assessments. The vast majority of things will trigger an environmental assessment. The quality of the assessment might be another matter, but the vast majority of projects out there of any kind trigger an environmental assessment one way or another. If anything, there's almost information overkill than anything. You can have an environmental assessment triggered for, if they're expanding the local post office and there's a badger that lives in the backyard, there's a good chance it's going to trigger an environmental assessment. And depending on how significant the project might affect the environment, it can trigger different levels of assessments. Both the provincial and federal governments have different levels of assessments. The highest level of assessment that you might see is called a Joint Review Panel, the JRP. And you would have recently seen one here, of course, with the Enbridge pipeline. The Enbridge pipeline triggered an environmental assessment, triggered a federal environmental assessment. It triggered a JRP. What they do with the JRP is they assign independent experts that have some knowledge of the project. And for the most part, like I said, it's a public information, it's a public input process as much as anything too. So the JRP has these public hearings that everybody gets invited out to. Some of you may have came to the one here, there must have been one here several months ago. And you may have came for that in terms of the Enbridge Northern Gateway pipeline. And what the process does is it makes all the input from all these different people public. Environmental assessment agencies don't necessarily have the ability to overturn what the federal government or provincial government, whatever department it is, that gets to make the decision. So, for example, with the Enbridge pipeline, it's the National Energy Board that gets to make the final decision. And the Canadian Environmental Assessment Agency can't really tell them what to do. It creates public information about what the concerns raised are, what the concerns of the experts were, what the concerns of the people were, and it forces the federal government to respond to those in a public registry. So they have websites. I think I provide them. I'm sure you get them if not. But there's websites for public registries. The federal government, the provincial government, both their environmental assessment offices have these registries. That's really what these processes are designed to do, is just to create public information for them. So yeah, use the websites. I know it may not be the most exciting thing that you could read, but it's definitely important, like I say, to understand some of this material. If you ever feel like going to one of these websites, I highly encourage it. Check them out and have a quick look and see what the environmental assessment process is really about. In terms of the AIP, in terms of environmental assessments on treaty settlement lands, so Under the General Provisions chapter, first of all, federal and provincial law still applies unless the treaty says something otherwise. The treaty doesn't say anything otherwise in regards to this. The environmental assessments will still be required on treaty settled lands. They will still be required in traditional territory. They will still be triggered for any of those same kinds of projects. And paragraph 1 of the environmental assessment chapter, there's this language that says any project on treaty settled lands that triggers an environmental assessment on Pitsinkailim lands will require consent from Pitsinkailim to proceed. It took a long time before the government was willing to agree to this. They finally agreed to it. We'll see that there is still one limitation to it. Bear with me, we'll come to that. Otherwise so what that means is on your treaty settlement lands, you'll have the chance to consent to any project that proceeds on them with this one limitation that we're going to come to just in a bit. So we also have in here the provisions that trigger consultation. You probably heard us say before that consultation obligations do continue. These paragraphs here, 4 through 7, environmental assessment, environmental protection, explain what that consultation process should look like in terms of federal ones, and paragraphs 8 through 9 in terms of provincial ones. So it's anything that might be reasonably expected to adversely affect your lands, your Aboriginal or treaty rights will trigger this consultation process in paragraphs 4 through 7. So that's not limited to your lands. We're talking about anything that might affect your lands, might affect any of your rights. I believe it also says affect the people, which is actually, I probably should have put it there because it's important that it includes cultural components to a large extent too. Yes, yeah. Expropriation. When I talked about the fact that there is still a limit, this is it. Now, expropriation is unfortunately still potentially possible in regards to treaty settled lands. I can at least say that there are a number of restrictions put in place, and I do feel those restrictions protect you certainly better than the past has. So what it says in regards to expropriation is that under paragraph 3, expropriation of treaty settled land by Canada BC is still possible. And then within the appendices, and I know we haven't made some of this public yet, but I think we will be in the very near future. But in the appendices is a few other provisions that do at least put some limitations on expropriation. They have to have a valid public purpose, Canada BC. They have to have no other reasonably feasible alternative. If it would be easy enough for them to go around, they have to go around. They have to try to reach an agreement first before they attempt to expropriate anything. They also have to take the most limited interest needed for the shortest time. What that means is, if all they need is a right-of-way for 3 years, then that's all they can take. They can't take the whole land. They can take a right-of-way for the 3 years, and that's it. And of course, if they do expropriate, they're still required to compensate for that. Just before we have reactions to that, let me just point out a few things about the realities now. Under Section 35 of the Indian Act, the federal, provincial, or municipal government can potentially expropriate reserve lands. And I have here, because a lot of people feel that may not fully understand Aboriginal title. I think, and that's just, it really is because there's so much case law out there that you have to read. It's really unfortunate. But I have a quote here in regards to Aboriginal title that I think is often overlooked. It's a very unfortunate quote. I don't like it myself, but it's nonetheless, it is in the Delgamuukw decision. It's part of Chief Justice Lawmer's reasonings in the majority, for the majority of the Supreme Court of Canada. And he says, in my opinion, the development of agriculture, forestry, mining, hydroelectric power, the general economic development of the interior of British Columbia, protection of the environment or endangered species, the building of infrastructure, and the settlement of foreign populations to support those aims are the kinds of objectives that are consistent with the purpose and in principle can justify the infringement of Aboriginal title. Aboriginal title, unfortunately, is not absolute. It's quite the list. So there's also some provisions in regards to lawmaking in the environmental assessment, in the environmental assessment chapter. Kitsilano can make laws in regards to federal projects or Kitsilano projects that are planned in Kitsilano lands. Your Kitsilano laws have to meet or exceed the standards provided by federal laws. You can't make it easier for things to happen, but you can make it tougher for things to happen if you want to. And Kitsilano can make laws in regards to environmental protection and conservation of Kitsilano lands, including prevention of pollution. So when we talked about the two branches of environmental law at the beginning, environmental assessment and environmental protection, you do have some lawmaking ability in terms of environmental protection. Admittedly, most of the chapter is about the environmental assessment part, which, like I said, really is the key piece. You want to prevent those things from happening rather than let them happen. So, a summary of what's in the environmental assessment, environmental protection chapter. Environmental assessments will still be required in Kitsilano lands. As we saw from those provisions that I pointed out, consultation will still be triggered anytime that any project might affect your rights, not just on your lands, but your broader rights. And you do have some ability to expand on environmental laws, and not making it easier for pollution to happen. Okay, I think that's actually all there is, because I know we're going to have some discussion about this. And there must be some questions and comments up there in regards to some of this material.
Can you go back to that, the quote to the doc, go back to the document?
Yep,
Can you explain it again? Read it again and explain it?
Okay, so as we all know, we have Aboriginal rights and Aboriginal title. And in the Sparrow decision, they talk about some of the ways that your Aboriginal rights can be infringed. They talk about how it would be fair if they were preserving a species of salmon, for example, preserving it for future generations of Aboriginals as well. So they've come up with they have this notion, there's this sort of a doctrine essentially of justifiable infringement, is what we refer to it when we're doing legal studies. And they do expand the same notion to apply to Aboriginal title. So even if you proved that you had Aboriginal title on lands, it doesn't mean that they're absolutely protected. If the government could show that they're doing one of these projects, that they're doing one of these projects, they probably have to prove that there's a certain benefit to your First Nation community as well. I'll admit that part of it. Because that's part of what they do in the Sparrow decision in terms of infringements. They point to the fact that conserving fish is within your interest as well. They talk a bit about balancing the interests, balancing their interests with balancing their fiduciary duty. And so, I mean, there's that aspect of it too. It doesn't mean that all these things can happen, but they're certainly leaving the door open for them to happen.
just looking at the EA process that they have here. As the Northwest here has been under economic cloud for about, I don't know, 20, 30 years here since logging and lumber has gone down. Fishing, not the way it used to be. Everybody's starving for any kind of economic loan here because everybody wants to come back and work. And right now, everybody is getting crazy out there, oil and gas developments and some hydro projects. And up north, they're thinking about doing a lot of the mining. We have a few mining claims in our traditional territory up in the Kale Lake area, and up in there's a coal claim on the big cedar there, and every time economics go down, the government decides they're going to weaken the environmental process because big business corporations, they want to get their business going, but they don't want to go through the environmental process the way it's set up, so they lobby governments with big money